Good afternoon, everyone, and good morning to those joining us out west. I'm Karen Langdon with the National Emergency Management Association. Welcome to the NEMA Empowerment e-learning series. NEMA is very fortunate to include amongst its members some of the most experienced and knowledgeable experts in emergency management. And we're very excited to bring you this series to help share their wealth of knowledge and work towards a more prepared and ready nation. Today, we're happy to present 6 years of public assistance arbitration under Section 5189 AD, Trends and Departures from FEMA Appellate Precedent. Thank you again for being with us today, and now it's my pleasure to pass the session to our moderator, Sam Van Kopp. Welcome, Sam. The floor is yours.
Well, thank you very much, Karen, and thank you everyone for joining us. You can go ahead and go to the next slide. So today's talk, this is how it'll go. We'll spend a few minutes introducing our panel, and then we'll talk for about 20 minutes with former chair of the Civilian Board of Contract Appeals, Judge Somers. She'll share her insight into the arbitration program, as well as her best practices and advice for those seeking arbitration. And then we'll get into the meat of the issues and the decisions, the most important decisions the boards issued between 2019 and 2024, the end of 24. It should be a very important bit of material for those who might consider arbitration this year, next year, and so forth. So first, we'll get into the introductions. Next slide, please. So back to the photos and my favorite part here. So Judge Somers, in the FEMA community, we know Judge Somers, of course, as the chief judge during the period when the board received its modern arbitration authority from Congress in 2018 and drafted its rules for the modern arbitration program. But she, of course, has a much longer career than that. She was also at the board as vice chair between 2008 until 2017. And she previously served as an Air Force Judge Advocate General. She served in the Department of Justice and in the U.S. Attorney's Office for the Eastern District of Virginia. That's what we call the Rocket Docket, both because it's very swift and unforgiving. And she was also a judge at the Department of Transportation's Board of Contract Appeals. She's currently in private practice as an arbitrator and mediator on a whole variety of subjects. She retired from the board in 2021, and she is a lecturer at George Washington Law School and American University College of Law. Thank you, Judge Somers, for joining us.
Thank you so much for that kind introduction. I wanted to make sure I unmuted before I started speaking. It's really a pleasure to be part of your panel, and thank you so much for organizing us. I look forward to talking about FEMA arbitrations before the board.
Thank you, Judge. And next we have Will Polk, and I imagine 90% of the folks on this call know Will very well. For those who don't, he is, of course, the Deputy General Counsel for North Carolina Department of Public Safety. And he was with the agency for 8 more years before that. He was also been the chair of NEMA's Legal Counsel Committee for the last 3 years. And if you've never seen a session in person of the Legal Counsel Committee, you really ought to at NEMA's either mid-year conference or annual conference. Every year they bring in a representative from FEMA to brief a new program or explain changes in existing programs. Both Will and the other state committee members, they grill this fellow very respectfully until they get some answers. It's always a sight to see. And we were very glad to have Will and that energy for today's conference. So thank you, Will, very much for joining us.
Thank you so much, Sam and NEMA, for having me here today. I really look forward to hearing from Judge Somers and the other panelists about arbitrations and share some of our experiences that we've had here in North Carolina with the arbitration process. So thank you again, and look forward to hearing from the audience some of the questions you have as well. And if you are going to be in DC at the end of March, please come by to join us at the NEMA Legal Counsel Committee. We plan to have a very exciting discussion as always. And thanks, Sam. I'll pay you later for the great being the great hype man there.
There you go. And Jamelyn Austin Trucks next is the National Group Lead for Grants Resiliency Master Planning with Atkins Realis. She has 29 years of experience in stakeholder engagement, floodplain management, budget development, contract negotiations, training, federal grant administration, and policy development. I've seen Jamelyn in her off time lecture about project management at events like the National Hurricane Conference. She is very concise, very knowledgeable, and we are very lucky to have her with us. So thank you, Jamelyn, and thanks for joining us.
Well, I appreciate the invite and pleased to be here as well, and look forward to hearing from the rest of the panelists today and in this discussion, which I expect will be quite intriguing and interesting, and to hear from the perspectives of this panel, their experiences. And I'm not sure that I am concise, but I will try to be so in the conversation today. I appreciate that, Sam.
And finally, Randy Jones, Associate Director with Guidehouse's Center of Excellence and Community of Practice, 16 years of disaster recovery management experience with expertise in utilities, infrastructure, capital budgeting, environmental planning regulations, and urban planning resources. Randy has an encyclopedic knowledge of FEMA regulation and policy changes. I find you can either follow half a dozen FEMA Twitter feeds, or you can just talk to Randy, which is what we get to do today. So thank you, Randy, for being part of the team.
Thank you for that introduction, Sam. Hope I live up to it. I'm very happy to be here with this distinguished panel. I'm looking very much forward to discussing arbitration, which is fairly new. It's growing legs. Obviously, it's been around for a little while, but it's still new to very many folks, and look forward to sharing experience and insights and hearing from the rest of the panel today. So thank you for hosting, and thank you, Nina.
Thank you. Thank you, Randy. All right, so we'll jump into the first session here. So Judge Somers, you know more about the birth of the arbitration program with CBCA than anyone alive. And it would be remiss if we didn't spend a few minutes talking about first principles here. If we go to the next slide. So Congress, in its authorization in 2018, seemed to give a lot of discretion to the board and how it was going to set this up. I put the actual statute on the right. It's very slight. It almost fits on a single slide here. So I wonder if you would tell us a bit about what the board wanted when it put together the rules that would govern these arbitrations. And for an arbitrator today, what's important for them to keep in mind when they go through this process to make sure that they're fulfilling the board's intent and accomplishing the objective here?
First, I want to say I'm speaking on my own behalf with my own observations and not representing the board, the federal government, or anybody else. So it's interesting, FEMA's arbitration started in a very limited way. We were just given jurisdictions by memorandum of understanding to decide cases involving Rita and Katrina back after the devastating floods of Katrina and then Rita. So we had those cases coming in. We had in our memorandum some general rules, but it wasn't as specific as it is now. And then that expired. That memorandum of understanding expired, but then it came back with Gustav. So we started doing cases under Gustav, but it was still very limited to this memorandum of understanding. Unexpectedly and without notice to us, the statute was modified. And we found out because one of my, the chief counsel just had someone contact him and say, "Oh, I see you got the broad jurisdiction." And we said, "Wait, what?" So that was really a surprise. But because we got it, we decided to take charge and immediately craft our rules so that we could have, at least if we're going to be surprised about this, we wouldn't be surprised about the rules. So we try to do it as consistently as possible with how we've been doing business, but also with some thoughts about how we could help applicants and the government respond to these rules as crafted. So it was really kind of a hope, a thought, and a prayer that we could get it in a way that made sense. But it wasn't something that we had any background knowledge about what to do. So a lot of it's drawn from our regular rules for Contract Disputes Act cases, but also from our experience as various lawyers and other practices. When we came to the board, we obviously had some experience somewhere else. So just using that to try to make sense and present something that made more sense than just a general adopting the prior rules.
You can kind of, I think, see some of that Contract Disputes Act DNA in some of the other arbitration decisions, especially around questions of procedure. It seems at times the boards may be looking back to that experience, which I suppose is a normal part of arbitration. when you're looking for a private arbitration, right, you're looking for the experience of the arbitrator is a big part of the decision. Am I correct here? Or?
Yeah, I mean, that's exactly it. I also, in my private life, I am now doing arbitrations as well as mediations. And my approach for these arbitrations are similar to how we approach the FEMA arbitrations, which was, what do we need to help decide the case? And so it's a very basic premise, but we need facts. We need facts that are produced in testimony and evidence, and then we need to have a way of deciding it. Because this was panels of 3, the decision process is more like in the private sector when you have panels of 3, which leads to the use of the panel members' experience, but also some diverse experience that may impact how things are decided. So that's kind of what we were doing at the time of the beginning of the FEMA arbitrations under the statute. And we did look to the Federal Arbitration Act. We looked to other statutes and regulations that governed arbitrations and pulled from those to see what made sense for us.
Thank you. I move to the next slide to keep us on time. So there are a lot of questions that stem out of that first premise question about the scope of the board's authority and what they would examine. I put this in here just for folks to be able to come back to the PowerPoint after the fact. So one of the questions that's come up is the question about whether, as a matter of equity, the board can grant eligibility. That's something the board has denied multiple times. There's a question about the extent to which a board can remand a decision in arbitration back to FEMA to resolve unresolved questions, often having to deal with the quantum of costs at issue. But what I wanted to ask next to you about, Judge, is another first principles question. Next slide, please, which still comes up and decides arbitrations all the time, which is the question of deference. So the extent to which a board panel defers to FEMA's interpretation of regulation, or even FEMA's interpretation, written or unwritten, of a policy interpreting regulation. And the individual board panels have come to very different decisions about this over the years. I'm wondering, just as a judge, if you would walk us through the thought process, since this tends to be such a decisive element in arbitrations. Just how does a judge think about whether to defer to a given interpretation? And then what does the public get wrong about that thought process? Just to help us understand this a bit better, since it is so important.
Well, I think if you start out with the beginnings of the FEMA arbitration, so initially our role and our belief was to decide these very quickly with very short decisions. So the very beginning decisions are very short, but that changed as we got more cases and different panel members just kind of looked at this differently, so that some panel members liked to do short decisions, some really wanted to go into more of an analysis and background, and so that then leads to having to decide whether or not to defer. And there is a dispute amongst judges as to how much to defer, and I think we'll see that not just from the judges' interpretations, but also from how the Supreme Court may lead us down a different road in terms of interpreting FEMA's and other agencies' regulations. I mean, I think that's up in the air, but right now you can see that judges look at things differently, and it's very much tied within their philosophy and upon the facts. And I'm not saying that the judges don't try to be consistent. I think they do, but just depending on the case and how it's presented may lead them to say, well, I don't see the evidence that FEMA actually thought about this in a way that we think makes sense, or that they did think about this and we're going to defer. So it really, even though it's not necessarily facts specific, it is in the way that it's approached in the decision-making process.
We got a great quote from a good friend. A great question from a good friend, Michelle Zaltzman, who asks about the application of Chevron. It still exists in this context. So the board, of course, is not been applying Chevron deference because we're an arbitration panel. It's not applying, unlike a district court, of course. But I'm wondering, in your context, when you're looking at the post Chevron decisions and how it might affect the court's application, if you have any comment or context on this.
I don't have any context, just my own thoughts on this. I think that even though it doesn't apply in arbitration, it is something that when you look at statutory regulatory interpretation, now we need to decide how much does that play into these arbitrations. And I don't know where it's heading, because that decision, even though it's been a year, I guess, since it came out, maybe less, I don't know if it's had any impact on most recent decisions. I haven't had a chance to scan the newest decisions to see if there's any reference. But I think to the extent that the board, the CBCA can be consistent with how it's been doing things, I think they will endeavor to do so until something impacts them that causes them not to.
Yeah, that makes sense. And I wanted to ask about, so sometimes a board panel will pause from its examination of a specific case in front of it, and it will spend some time to opine and build sort of a framework to think about an issue. And the board's done this a few times on deference, particularly in its very first case, Livingston Parish. And I'm wondering, do you think most boards, since every arbitration is independent and a board panel isn't bound to follow the previous holding of an earlier panel, do you think most judges think about, or do they at least start their analysis using a framework like that? Or do you think for most folks, it's first principles, and unless you're on that panel, you may not follow that framework?
I'm hesitating only because it's actually both. So some panels will look to first principles and they'll use that as their framework. Other panels will look at it in a different way. And despite the fact they are not bound, there is always discussion amongst the panel members and the board as a whole as to how to approach these cases. And a particular case may involve a change in the approach just because of the way that the case was presented. That's not a great answer in terms of I can't give you any guidance as to one or the other. It's just the way it is.
Understood. Will, if I could bring you in on this, for the practical consequence. So we've been talking a bit about why this is important for applicants who are currently arbitrating, thinking about how a judge will think about deference. But you were involved, or you knew an applicant who was involved with a case where deference was very important. So I'm thinking about Topsail Beach, which is on the slide right now. A case that I think the board panel deferred quite a bit to FEMA's interpretation of a technical issue that ended up, I think, underestimating the amount of sand that was eligible to be replaced, which affected the cost. I wonder if you would talk to us a bit about the practical consequences. Will you have an ambiguous FEMA policy and how that affects an applicant both in performing the work and then after the fact, how an applicant goes about trying to recover given that and given the risk of a deferential opinion to that FEMA guidance?
Sure, thank you. And again, like Judge Somers, like I said, with first disclaimer, I'm speaking as myself and not on behalf of the Department of Public Safety. But in my experience, our role is it's more of a grantee. So in arbitrations, you have three parties. You have the applicant, you have FEMA, and then you have state agencies like Emergency Management, who is the pass-through agency for the public assistance funds. So we're in the role of the grantee, and we do work with the applicants when they do request for arbitration, when they have got a detrimental determination memo from FEMA as it relates to their reimbursement. In a situation of Topsail Beach, it was a very technical case because and this is something that a lot of coastal communities are very familiar with beach renourishment, which is an eligible activity under public assistance. But the question became, how do you measure depth of closure as far as when, very technical, it became an issue of dueling experts, quite frankly. FEMA had their interpretation of their policy. The town and had their experts as far as also have retained counsel to help them with this determination. So when it comes to these types of as far as boots on the ground, what sort of happens, at least for the Division of Emergency Management here in North Carolina, we take the position of generally trying to work with our applicants to try to get them to get whatever maximum federal dollar that they should be eligible for. So in this context, we really did, dig into myself and our co-counsel at the time really got into the guts as far as understanding what depth of closure is, trying to understand. Yes, we know that the agency, looking at prior arbitrations and situations, yes, panels do seem to defer to FEMA but where we could also make a case for why we felt that, given the nature of the beach profile, we felt that there was good colorable claim that the applicant was making as far as why the depth of closure should have been there. So again, so when that happens, we're working with the applicant. Of course, at the end of the day, the applicant will decide what course they want to take as far as their arguments, but we as a grantee will, look to our own deference if there's argument equity, as we mentioned before. Sometimes we'll try to, make that argument if an all independent determination that, maybe this is a, item of first impression, or, because of the deference that park panels sometimes give to the agency, we may or may not be able to go to what the applicant is arguing, but we'll try to provide our own experts, and sometimes we have had situations where we've had employees for emergency management give their experience as far as how FEMA has treated cases like this in the past to help inform the judges about what the agency's prior practices has been, especially if you're trying to get to, make that point about deference to the agency. You can see how the agency has interpreted these rules and regulations in the past in order to color, hopefully, a favorable opinion for the applicant in the case at hand.
And there have been opinions, particularly in documentation, and the latter slides of this presentation. If we don't have time to get to it today, I urge people to go through the presentation afterwards and look it up, because there have been a few cases where board arbitrations have looked at the course of dealing or FEMA's actions in the past, with how it's treated a particular applicant, and determining whether or not, in that case, documentation is sufficient. Perhaps in this case, whether they've applied the same policy consistently, as an element in determining what's appropriate. So, I mean, getting testimony to that effect can be very effective. And to Will's point also about a matter being a matter of first impression, the board is very young still, and so this was the first case with a matter of sand replacement, and there are a lot of matters that are still that way. So it's important to keep in mind there are a lot of issues that are like that. Well, I don't want to monopolize things. Let's go to the next slide here. And before we dive into the specific issues and some of the most important board decisions on these specific issues, I wanted to ask about general advice and insights for arbitrators. Start with Judge Somers, but also open it up to the panel here on these general issues. So Judge, I wonder, drawing both from your time at the board specifically for these programs, but also for your much larger experience arbitrating outside too, to begin with, what are the considerations for an applicant deciding whether they should, in the first place, request arbitration? I think a lot of folks are maybe on the bubble about that, and there's not as much advice there as what to do after the fact.
Sure. So, I mean, I have never been in the position of advising an applicant to seek arbitration, but what I would imagine would be important is to evaluate the likelihood of success, so that I can tell you in the beginning, when we were doing the Katrina cases, when everything was new, applicants just filed, to seek reimbursement, but they didn't think about the fact they actually needed to prove it. So no one was tracking at the time, how do you quantify the damages? How do you establish the damages, especially with repeated storms? You have to be able to distinguish between this storm and that's really hard. So an applicant who cannot produce that evidence might consider for themselves whether or not they're able to meet the standard that's going to be required for them to establish entitlement. And I think that that's a consideration that needs to be done early. And it may require a consultation with, maybe an inside expert or whatever, but you need to have the evidence up front.
And opening up for the rest of the panel too, if anyone has notes and experience with this, I know Jamelin and Randy, you've doubtless been in situations where you've held applicants with this. One of the perennial comments from the judges in 2023 in the last webinar mentioned that oftentimes they had applicants, to Judge Somers' point, who had filed arbitrations but hadn't had the evidence necessary to quantify the damages, spent 90% of the case just arguing for eligibility, but then to no purpose. So a difficult thing to think through.
Yeah, and I think to your point, Sam, that was one of the points I was going to bring up is that, when you're even looking at the appeal itself, you oftentimes need to realize that the process and the arbitration and the information that you've presented, right, isn't necessarily applicable, or you need to repackage and repurpose and have the focus itself needs to be kind of center on the arbitration filing itself versus necessarily what was covered during the appeal. And I think that's really a driving point that I'd like to make.
Yeah, I would also add that this is unfamiliar territory for a lot of applicants and recipients of funding, and those who are trying to seek resolution where they feel like communication has not been the greatest or their understanding of everything is not the best. And so understanding what processes are available to them, what resolutions are available, what timing of processes look like, how to document, how to prepare for those conversations, how to decide whether a second appeal or arbitration is best for them, opening up the books, looking at case studies, and preparing their documentation, which should be a prerequisite, right? Like, we want to document everything to the T and have those checks and balances in place so that when you're providing that packet to the board, there's no question of the journey that you've been on and what you're looking to resolve in arbitration.
Yeah.
I'm sorry, please go ahead.
Yeah, and also just looking at the bullet points, some of the things that I've seen, at least in my experience here. One, having an attorney, I can't, even though I know many of these jurisdictions may be cash strapped and doesn't have an amount. I think whether it's an attorney or someone or a consultant who is familiar with the arbitration process is very critical, because I think it really dovetails into three other bullets that the judge Lester and the panel made from 2023, because I've seen in a situation where applicants have gone in, at least standing from the grantee seat, seeing where applicants have gone in, if they didn't have an experienced hand at the arbitration process, focusing on the entitlement issues, getting into the muck, even though with an attorney, sometimes managing the time could also, it cuts both ways having counsel. Sometimes it gets, too adversarial versus you get stuck in the muck. But also, and the fourth point, it also just regurgitating the earlier arguments, and just restating what was already in their brief. So if you're going to request a hearing, make sure you have fresh items that you really want to discuss with the panel, not just regurgitate what you said in your brief. Because again, the whatever hearing is conducted, it's a very tight window, and you really have to manage that time efficiently and effectively so that you can get those issues out there and really not regurgitate. Especially some of the ones if it's a jurisdiction that may have some have gotten congressional or third parties engaged in it. A lot of times they'll, detrimentally rely on some of that, or, what the FEMA staff member may have said to them, instead of, again, getting to the point that's been made earlier, not having the adequate documentation, to show why their costs should be reimbursed.
I completely agree with Will, and also with the 4 points that are made. I would add to that it's really important to remember that this is an arbitration, not a trial. So sometimes people present, particularly the attorneys representing the sides, really would have liked to have been in front of a jury. So they present their case in a very dramatic way. Everyone who's on the panel cares about the people who have suffered these harms, but they don't need to be argued about or presented in an aggressive way. So, I've seen attorneys who object to everything the other side's doing, and it slows it down, and it causes the panel members to be irritated because their goal is to get as much factual information as they can. They can figure out the law, but they don't have access to the facts like the parties do. So I think it's really important to remember that the goal of it is for them to gain facts so they can decide the case, not to be entertained by masterful skills. That's not necessarily all that helpful. So that's something I always think about as well.
One other thing I'd like to bring up before we move to the next slide is, as a sub-applicant, make sure you have an open dialogue with both your FEMA stakeholders and your state parties, right? Let them know what your intention is and the process that you're seeking and resolution that you're seeking, because it's very important to have that state support, I believe. It's not required, Judge. I think they're not required to participate. However, it's most beneficial to everyone involved if all stakeholders are involved and on board with the process moving forward.
That's true. And I was always surprised when one of the parties did not appear, did not seem to be engaged. It doesn't help the applicant at all.
I'm always struck by in both the advice this time and the advice in 2023, solid points of good presentation skills and good management. It may seem, at first glance, that things that everyone would think of, but the reason it comes up again and again and again is that it's not, right? People come to these arbitrations not having done these things, and that's why the judges feel so passionately about it and want so badly to tell folks. So it's one of those things that's easy to talk about, very hard to do, and so that's why we're mentioning it again. All right. Before we move on to issues, any other last bits on this? Sorry, Jamie, go ahead.
Nope, I didn't have anything.
Oh, okay. Going once, going twice. Okay, let's hop into timeliness, and we are right on time, so that works out great. Next slide, please. All right, so most interesting issue. This decides whether or not you get to the board in the first place. So timeliness and arbitrability. And there is no other issue where the board has broken as dramatically with FEMA than this one. So it's, I think, very important for applicants to be aware of this, and because FEMA is not changing its stance either. So the board is continuing to allow arbitrations that FEMA will continue to deny. So next slide, please. All right, so these four decisions sort of right off the bat are things that I think applicants need to know about. So an untimely appeal is not untimely for the purposes of arbitration. If it has been filed with the applicant or with the state recipient timely in a timely manner. If it's untimely only because the recipient hasn't forwarded it to FEMA within the requirement of 206, it doesn't matter for the purposes of arbitration. And the reason is very simple. The board has made this opinion 3 or 4 times at this point. The statutory right to an arbitration is provided by Congress, and it cannot be abridged through this claim processing rule that's provided in 206.206. And so the cases on the screen talk about this: Beaumont, Laramie County, and in Minnesota Matters is important in 2024 because a board panel affirmed this even after the amendment of 206.206 earlier this year. So a very important thing for applicants to know. As I understand it, FEMA is continuing to do this. They sort of have no other choice. FEMA's regulation says that if the recipient didn't forward it to FEMA within 120 days, they have to. But the board has no choice. There's a statutory right to an arbitration. So long as the applicant timely filed its appeal, you're still timely. And Will actually wanted to ask on this before we move on. Just what is that process of the recipient, the state, reviewing that initial application before pushing it forward?
Yes. So our team in our recovery section, fortunately or unfortunately, depending on how you look at it, North Carolina does have a pretty robust recovery section, and so our whenever an applicant thinks that they're going to request an arbitration, they do loop our team in, early in the process, so that make sure that everything is aligned and able to be processed. I know we had one of the, I think it was around 2019. There was, I think, before the rules had changed as far as some of the timeliness. We did have a situation where an applicant did file their application with us, but unfortunately, I think the staff at the time did not forward it to FEMA. It was the Elizabethtown case, and at that juncture, the arbitration was dismissed. But because of those experiences and just having better training with staff and everything, we make sure that if an applicant does want to avail themselves of the arbitration, we let them know about the appeals and arbitration process, and the case manager assigned to the project will work with the applicant.
Which makes sense. And it gets, so the other interesting situation where the board has consistently found that an arbitration at least would be timely, even if an appeal would not be, if you had gone through the second appeal process, is the circumstance where an appeal right is communicated after an initial determination memo. This is a bit technical, but it came up twice. So first in 2022 in the case on the screen, Board of Trustees, and again was affirmed in 24, a circumstance where determination memo comes in, an initial appeal is denied, but after that there's a project worksheet. That worksheet is communicated from FEMA to an applicant. With that project worksheet, FEMA notifies the applicant that some money has been appropriated at that point, has been obligated to that project worksheet, but not all the funds have been requested. And in that communication, FEMA attaches its right of appeal. So, by the way, you have the right to appeal this decision. The board has found that that communication of the right to appeal or arbitrate sets the clock for timeliness. And so now, rather than the earlier determination setting the clock, it's this later notification. And in the case on the screen, it was very important. It was like a 6-month difference. So suddenly a case that would be dismissed on an appeal, it has an arbitration ability, and its timeliness is timely for that purpose. And I wonder, Jamelin or Randy, to the extent to which a project worksheet communication is used as another way to communicate a determination in this manner, or is this a process that the FEMA no longer does? Or if this is not something you've run into?
Well, I can speak to a little bit, and I will say that it isn't something that I've seen, a significant prevalence. But what you have seen from a notification standpoint, and maybe not directly, maybe more tangential, maybe than a direct alignment, is that the process of notification has also taken different iterations. And I kind of want to speak to that because even later on in this webinar today, we talk a little bit, we focus a little bit more on the COVID era, right? Yeah. And there was processes that were implemented from notification standpoints and in applicants' right to appeal, or even we call it the classic email notification of select option 1 or option 2, right? And I see Will smiling and nodding his head at me for this one, because it was incredibly confusing to the applicants of what were their rights. Have I completely relinquished my rights to appeal by selecting option 1, which was I accept that these costs aren't eligible, right? I'm not going to be able to go ahead, but I need my money, right? So go ahead and move forward through the process. Or option 2, yep, you can go to a DM, and yes, you'll have a right to appeal at that point. But the timeline, right? And it was kind of a stick of just trying to move people through the process. And I feel like, in some instances, it's that either lack of communication or change in processes like this. In my mind, this is a little bit of a change in process or an inconsistency in way something is communicated, in a similar vein to what was experienced. And then, then applicants don't have, maybe not understand what their path of recourse is, and not even realize that they may have, no longer have that path of recourse when it comes to the appeal process, and therefore ultimately, to the arbitration process itself as well. And so I think, that is, a process, and changes in process or lack of consistency is a concern. And, how do we alleviate that? I've also, experienced what Will was talking about, where, applicants can submit, timely, and then it may not make it through, at the state level, make it through the 120-day timeline as well. And, the openness, for the arbitration panel to reassess that, I think is actually incredibly valuable to the applicants when, particular situations are out of their control. But it also is very important that we kind of lean into working with the applicants, working with the communities, working with and helping them understand what their responsibility for timelines, and then also working with the state level. Like, our role is also to be the communicator and to help everyone along that path and better understand and interpret those nuances and the changes in process and how it might impact those applicants, and work with them closely, and all the partners that are kind of in the, the stream of a project and the process that it follows, and in those applicants and the impacts it might have to them.
To Jamelin's point, if you're an applicant that's found yourself in the position of having been told at one point that you have a final decision and appeal rights, and then suddenly that no longer exists, you really should look at these cases cited here, and specifically regarding the rights of specifically regarding the Board of Trustee and Bay Medical Center cases, because the board is fiercely protective of its right to hear these cases and decisions, and fiercely protective of its right to arbitrate. So, and there's a point in the chat from another good friend, Wendy Ellerton, who has an excellent point here, which is that in considering these timeliness questions, there's also consideration of the merits. And so in many of these cases, the board is considering the procedural question. It then considers the merits of the appeal. And just because you win on timeliness and you win on procedure does not mean you will win on the underlying eligibility of your case. And in many cases, you'll lose on the eligibility of your case. So it's important to remember that it's not by itself sufficient. But of course, getting in is the first step. Okay. Next is actually Judge Somers. I was thinking about you when I was reading this case, because it's the board has held that when arbitration or appeal request falls on a Sunday, it can actually be submitted on the following Monday. We were talking before about the DNA of the board, its Contract Disputes Act, and its federal litigation past. Maybe informing some of its decisions. This definitely feels that way because there are so many administrative rules that operate under this same requirement. This particular case found that if the due date is on a Sunday, it can be filed on a Monday. I think the same logic would apply for a Saturday or a national holiday. But it just reminded me of again that DNA and that influence, Judge, because that same rule applies in other contexts that we litigate in.
That's right. I mean, since there is no appeal, in terms of trying to interpret certain things as they come along, obviously the board's going to go back to what they know. So, the Federal Circuit has made a lot of rulings about timeliness. Maybe it shouldn't apply to arbitrations, but why shouldn't it? They're not citing the Federal Circuit, they're just using the same rationale. And I think as the Supreme Court has started looking at certain things like timeliness and things like that in a broader sense, I think that the board is also trying to at least not use very specific limits when there is a way to actually go through, get the application before them, and then decide on other stuff. So I think, the goal is to try to resolve the cases, and not like we used to do back in the day where everything was certification. You didn't use the right language for certified claim under the Contract Disputes Act, you're out. Well, that's not how it is anymore. So I think that's kind of the underlying premise there.
Next slide, please. So then to wrap up this issue of procedural matters, the board did what we were talking about a moment ago, where it paused in one of its cases and it laid out a framework. So if you're an applicant that's been denied eligibility because of a procedural matter, you didn't even get to the point where you could argue to the merits, the board has sort of laid out a framework for you to frame your dispute. And it has framed into 4 buckets. So if we were in federal court, we might think of these as issues of jurisdiction, but since it's arbitration, we instead call them issues of procedure. or arbitration challenges. And so if you read this case, it'll walk through this. I'll just highlight a couple quick things because we need to move to the next section. So in issues of standing, this often comes up in the context of private nonprofits. Not that other folks don't have problems proving that they're an applicant, but private nonprofits is a particular issue. And I want to link in Randy and Jamelin here for your experiences, because private nonprofits have a whole suite of issues they need to think about. If you are a private nonprofit out there, I highly recommend you read this case, Deweese Island Properties. It's an excellent case of both how the board panels think about deferring to FEMA regulations and policies, and it's a case about how private nonprofits can prove their eligibility based on secondary and tertiary uses of their property. But Jamelin and Randy, if you have any notes for private nonprofits, this is a good place to opine.
I think each disaster, Sam, is a bit different, right? Each disaster, each situation is its own animal when qualifying it and quantifying damages of eligibility for FEMA. And when it comes to private legal responsibility, it's, authorization of action of what you're doing in response to a disaster. It's also the documentation and follow regulations and authority in accordance to the POPG and guidance. So there's so many layers when it comes to private nonprofits of making sure that there's no missteps and falling into those pits of despair in order to meet the requirements for eligibility under these concerns. And while we're on the subject of arbitration and timeliness, especially for these private nonprofits and governments as well who have never done it before, I want to kick back to that previous statement of the timeliness. Just make sure you're not relying on interpretation of when that clock starts. Ideally, you're maintaining communication with everyone. You know when that DM's coming. Make sure you start your clock then, to not be one of those applicants gets removed due to a technicality on timeliness. Make sure you're within the 60 days. Make sure you're coordinating with your state in order to get some notes so you don't end up in a precarious situation. I think it's nice to have, exceptions to the rules and favorable outcomes to those who have missed those timeframes. But I think preparedness is key, right? Fortune favors the prepared. So in order to have that checklist and have that plan in order to get your arbitration or appeal, if that's the pathway, and then understanding precedent on what meets eligibility requirements. Again, relying on those experts and where they've seen that available and allowable.
Yeah, and Randy, I'll kind of build on that just a small amount, because I think there is really an element here when you're working. There's almost two languages that we speak, right? And private nonprofit world, the language that they speak and what they do and what services they provide and how they speak to that, right, doesn't always align in an apples to apples translation into FEMA policy and POPG interpretation of what that is as well. And I think that's the other role that we have is helping them understand and kind of translate and having, providing them that guidance of how to present the information, how to explain who they are, what they do, and how is it aligned, and how is it eligible, right? In that context. And again, the terminology is incredibly important to making those alignments and the interpretation, because it's who's reviewing it on the other side. And that's where we end up, hopefully our job is to hopefully avoid the, getting to the appeal or to avoid getting to the arbitration, right? I feel like really that is our role. We ultimately, it happens and we get there, but it is trying to help them understand those roadblocks that do exist in that miscommunication path, and understanding of the work that they do. And then, and helping them develop and communicate effectively.
Yeah, and to second Randy's point, don't ever please rely on any of the exceptions that the board has carved out for for applicants to get their day in court. Apply as soon as you can. Last bit on this point. So the second bucket for procedural challenges here is what the board has started to term arbitration authority, which is typically, do you reach the monetary threshold that you need to in order to be in arbitration in the first place? This often comes up in the issue of whether settlement prevents you from arbitrating. The answer is no, so long as the value at the time the arbitration request was made meets the statutory limits. However, it is possible to disqualify yourself if instead of settlement, you choose, you make it clear in your actual arguments that you're not going to dispute some quantity of the amount. And in so doing, you decrease the threshold below what you need to stay in arbitration. That's the holding for Metro St. Louis district on the slide right there. Just something to keep in the back of your head. Very rarely comes up. But keep that in mind. If you're settling, you're fine. But if you're just choosing no longer to dispute, you have an issue. And then the other issue that this comes up in is if you have to sum multiple project worksheets in order to get to that statutory limit, which the board has generally allowed. So next slide, please. And then for the sake of time, we'll leave this here. So the third and fourth, procedural eligibility is usually timeliness. But getting back to one of the things that Judge Somers said about thinking about the board looking at federal precedent, Supreme Court precedent even, in deciding how to apply rules where there's not really a source to go from in FEMA policy. The decision the board made in Laramie County, where it talked about claim processing rules, and it analogized to federal precedent as to whether a claim processing rule would keep an issue from getting into court in the first place. If you have a situation where your appeal is not timely or is barred in any other aspect for procedural reasons, look at Laramie County and look at whether or not you can analogize to a claim processing rule case in federal precedent. There might be an avenue there for you. And the final point here is deference. This is not what Judge Somers was talking about earlier when we were talking about deference in general. This is deference in the context of procedural disputes. And in that case, the board's made it very clear that there are very few circumstances under which the board's deferring to FEMA's interpretation of the board's jurisdiction to hear these cases. As we were talking about in regard to Wendy's comment, the board will often hear cases, even if there are shaky issues of procedure, may even deny the case, but it will hear the merits first. All right. Any last comments from anyone on the panel on questions of procedure or timeliness? No? Okay, let's move on to the next issue. One near and dear to everyone's hearts, I think. Next slide, please. So COVID, most arbitrated dispute of 2014 will probably be so for 2015 and 2016. Next slide, please. Just a couple stats, and then I would love to open up to the panelists to get your thoughts and predictions. So fifth year in a row, the board's had a record number of cases, 42 substantive decisions. So that's discounting the number of cases that have settled after being filed. And there's been a decrease in the number of applicants who have been found to be eligible in arbitrations, usually around a third. Decreased this year about 19%, still higher than secondary appeals, which are about 13%. And the overall reason for this is that COVID cases. So went up to about 40% of all cases in the board were about COVID, primarily about COVID. And of those cases, only one prevailed. Now, there were two other cases. So 40% of cases, all cases had COVID. Only one found the applicant to actually be eligible. And we'll talk about that case in a moment. There were two other cases that happened during COVID, but weren't about COVID. In those two other cases, there was some eligibility found. But of those cases that dealt with COVID, specifically as COVID, very little eligibility. And that's affecting stats across the board. So that's the top line number. And I wanted to get the applicant's thought. So, Jamelin, this I'm sure you're working, on this on a regular basis, and Randy, what are you finding right now? Biggest challenges in the industry with appeals and protests with regard to COVID?
I'm seeing early decisions and inconsistency in FEMA findings for eligibility across COVID. And I think that's just the nature of this disaster and how widespread it was, and the different applicants and how they approach the situation and their resources, right? When we talk about equity, of what level we're starting off from in the response. There was a little bit of a disconnect between FEMA response and those emergency guidance and what was going to be eligible, and also catching up to that learning curve of documentation and that layered eligibility and the burden of proof and documentation from an applicant side. So in a lot of cases with smaller sub-applicants or more rural applicants, you have situations where there was turnover of their FEMA team, maybe inconsistencies with state providers as well, just like not having a clear path of communication or what was expected from them. And so the longer you get into a disaster, the harder it is to go back and have that historical context and rebuild documentation, right? It always is helpful from the beginning, but we can help. There's usually data and ways to backtrack it, but it's hard, right? And what I'm seeing with PDMGs or FEMA groups in general is skipping ahead, and all of that historical context and those conversations and the directives to build different methodologies kind of skipped over, and they're issuing DMs, possibly some groups are issuing DMs based upon the first submission and not the different iterations in between. And so the decision comes out, doesn't account for everything in between, and forces a sub-applicant and applicant into appeal, which is maybe why we're having increase in those cases. I think it's important for sub-applicants to reach out to their regions, reach out to other regions if there's situations that are similar to theirs, even in healthcare, especially the healthcare systems, in what worked for them, what methodologies, what got it across the line with FEMA obligation, because that helps bring a solution to the team. Because I think everyone wants to see a win, wants to see recovery happen. And it's, again, relying on that burden of proof and that burden of documentation that it's eligible expenses and that it was COVID related.
And honestly, Randy, you said that incredibly well. I think it's very similar to what we're seeing. Even, in many cases, the applicants that we've been working with, since June of 2020, really is the time frame. So it's been a really long time. And there's been just an incredible amount of change and policy change, and it's not a traditional, disaster. And that interpretation or even just the policy at the time a decision was made has changed, right? And then we are just now seeing more of a prevalence of that revisiting. We may have a project that's now in version 4, and this is a specific example that's going on right now, and it's version 4, and now we're going to revisit costs that have already been obligated and been validated, and now we're going to revisit them again for eligibility. And I think that alone is causing consternation, causing challenges to our applicants to say, hey, we thought we were nearing the finish line. Why are we revisiting, right? And why is it being reevaluated through another lens when we felt we were, all on the same page at this point, right? And I think there is that challenge. I think, we worked significantly and do continue to work with the medical facilities and, the whole RAM process in and of itself, and the methodologies of, I'm getting face reactions with my commentary, but I think that is, it's a challenge for the applicants, the type of documentation that they typically track their costs and expenditures and their personnel. I mean, it's just not the same. It's kind of speaking back to the PMPs and speaking the language and speaking FEMA public assistance language. It's just not the same. And their documentation, how they track it, and just having to translate is difficult, and having them understand, and work through that process. And I think more than anything else, the role is to help them understand. But then, there's going to be challenges, and I think there will be challenges when we get to this increase, in arbitrations, right? And projects going to arbitration are likely going to be some of that, right? It's just, there is a difference in what's available. And it said we can, you can go down and continue to track, but foundationally, it is just incredibly different. And I think that it likely is going to be a lot of the increases that you're going to see and the challenges moving forward. And I think in the relation, in the context, especially of the medical facilities.
And some of the cases we'll get to are medical facility cases. Sorry, go ahead, Randy.
Mm-hmm. Yeah, I was going to say they could be a little charged. I know we talked about coming into the room with a practical mind, right, and a calm mind of arguing. But it's been a long journey, and if they were doing it in a bubble, it would be one thing. But they've been they've been working with stakeholders through this entire process. A lot of these project workbooks were built in the middle of COVID. As Jane said, guidance changed a lot. We saw a lot of regions kind of pausing to see what would be the precedent so that they could follow it and kind of rubber stamp it for each applicant. Everything worked the same. Systems weren't working the same. They don't have, the same systems. And so making, troubleshooting and problem solving for these applicants really took some creativity, and it's possible, but it needed that expertise and historical knowledge of what works and what typically doesn't work when FEMA's kind of flying in that gray space. And it'll be interesting on those eligibility recommendations of them building these methodologies when considering they're incurring costs while you're telling them to go with this methodology, and this methodology should work. So if they're missing documentation and they're missing content and they're missing eligibility requirements, there was a full team there not telling them to acquire these data points along the way. Yeah. And that's going to be interesting to see how that plays out in future guidance and future disasters.
There was a case 2 years ago, Sonny, I'll find the CBCA number, but one of the elements of the cost reasonableness consideration was the communications at the time, the contemporaneous communications about the cost documentation and the reasonableness of it. The board found that based on that contemporary communication, the fact that they were there the whole time, as you're talking about, Randy, that was one of the reasons why it was found to be reasonable. It's an isolated case, but it's an interesting example. Will, how about from the state perspective?
Yeah.
And interfacing with FEMA. Yeah.
Yeah. We've only had one arbitration as far as it relates to COVID-19, and that was one we had last year with the city of Public Works, Fayetteville, and it was a question about sequestration and operational costs, and basically, of course, it was denied because it was basically not looked to be, it wasn't a result of increased demand. So, as far as the public health aspect. So, so for us, we're still, quite frankly, in seeing where things are at the CRS and also just in the normal appeals process. So I don't have too much I could really add at this point as far as from the arbitration standpoint. Of course, there is. We've had situations that pre-appeal or pre-arbitration where documentation has been contemporaneous as entities were submitting their, working up their project worksheets and all as far as eligibility and eligible costs, and getting documentation to basically support their reimbursements. Some of those ended up being a situation where it may have been paid for out of the another funding source. Because given that there were two different funding streams for COVID as far as eligible expenses, some of them went in one direction versus the PA route. So, to really, other than the Fayetteville case, where again, we did cite to the I think this is the Miami decision, where there was, I think, the unicorn that was granted eligibility. We haven't had that I think that was the one case, but the one that we have had gone up, it just hasn't been, it was not successful. And part of the reason was because to Randy and Chamberlain's point, it's just the documentation as far as the existing policy. One of the things that did come up was some of the existing policies that the entity had what was just lacking, quite frankly, and they didn't make the appropriate corrections to be able to track those costs to show it was related to public health. It was just true, true sequestration and just for to prevent people from getting COVID, but it wasn't. That wasn't was on its own. That wasn't enough to get us across the hurdle.
Fayetteville is a very interesting case. Actually, would you push forward 2 slides, Ashley? And we can talk about it right now because, and then we'll go back and talk about the one successful COVID case in 2024. Part of it is the documentation thing that Jamelin and Will were talking about. But the other really interesting thing about this case is it was exactly the same facts. I mean, it even involved a wastewater treatment plant. The policy regarding overtime was almost exactly the same. It was both a little bit vague. And they were quarantining for the same reason. They were keeping staff on post because of the threat of COVID, and they were providing essential services. And they lost. And in one case, Essex, joint meeting of Essex and Union counties from 2022, it's been the last, the forlorn hope of every COVID applicant that's seeking arbitration for years. Because in that case, the board read the decision, read FEMA policy very broadly. It read policy documents to find that there was an implicit finding that there was no longer a requirement to prove increased demand for services that were otherwise increased operating costs. And for that reason, the applicant in joint meeting of Essex and Union counties was found to be eligible. But in Fayette Public Works Commission, almost exactly the same facts. The panel acknowledged the decision in joint meeting of Essex. The panel acknowledged that this other panel read the same policy differently. Panel acknowledged it was the same time period of COVID, the first few months, but the panel said that they did not read those policies the same way and therefore denied eligibility. So it's an important, at this point, it's important to remember that every arbitration panel makes its own decisions. And I think the other takeaway you take away from it is that when you're doing your due diligence, you have to figure out, who's on your panel and how they've decided cases in the past. And I know that this applicant did this, and it was just sort of bad luck on their part that they were assigned Judge Chadwick in this case, because the first decision Judge Chadwick had split from Judge Lester and Judge Ziscow to write a dissent, which is a rare thing in an arbitration case, saying that he had disagreed with the reading, the broad reading that Judge Lester and Judge Ziscow had done in Essex and Union County. And it was, in the end, Judge Chadwick who had chaired the panel in Fayette Public Works. So all that to say, I think it's a very important decision. It tells you a lot about deference and the range of board deference and how decisive board deference is in finding cases. And it also tells you what you're up against with the COVID cases. So many of them depend upon increased operating costs, just like Jamelin and Will were talking about. So if we can go one slide up now, Ashley, to talk about, I think this is important since it was the one case of success on a purely COVID issue, talking a little bit about Miami Beach So again, focusing on the judges in this case. So this is Zhiskow again, Virgilio, and Goodman. Category B cases, emergency protective measures again. Three broad arguments, and we'll go through this very quickly because our time's running out. Seeking overtime, labor, equipment costs. They were firefighters, but the decisive element in this case was they were firefighters that were segregated into a new unit that was only going to respond to COVID-19 calls. And that ended up being decisive. Initially, FEMA denied the costs because for lack of documentation, they could not prove that the patients they were responding to had COVID as opposed to a different kind of infection. Given that this is the first few months of the pandemic, I mean, when testing wasn't available, I find that a little bit ridiculous, but the board denied that argument anyway as being not required by FEMA policy. The important thing here is this is a case where the board denied FEMA's position that increased operating costs would have denied eligibility. And they found that because the fact that this was a newly created unit, it wasn't performing its routine duties. It was performing these specialized responses to COVID. And on that position, I want to ask Jamelin and Randy, other panels have not bought this argument, right? I'm wondering how many applicants you've worked with have tried to characterize like a special response, or is it possible to do this in other ways? How transferable is this sort of argument?
Well,
if at all, yeah.
Can I first of all let you know that this is I'm very familiar with this particular case because this is actually an applicant that we have responsibility for supporting on COVID, and our role is for FDM. So
well, congratulations.
Yeah, great. Yeah. So I saw this one pop up, and I was like, oh yes, I have a personal experience with this, and yeah, when this project came through, it was part of the entire the process of the analysis and the evaluation, and again, as you said, that first pass from FEMA was that absolutely not eligible. But I do think, I think from our team's perspective, when we evaluated it, we kind of landed where you did, Sam, and didn't make a whole lot of sense. It was earlier in the process, in the response to the disaster and to COVID, and they consciously, I think, did what they could, right, to be able to segregate the activities from traditional or their standard operating for EMS and for fire, right? And they made and all the other documentation was very much in line with your traditional, forced account labor and your 214s. It was very much aligned with what would be required from traditional documentation standpoint. It was just this unknown factor of COVID, right? And that this decision kind of leaned into the requirement at the local level for social distancing. And I think that was also something that when we were reviewing it initially, also called out, right? Okay, that made it distinct from, and to your point of, would this apply to other events? I mean, I think COVID it's I always like to say it's kind of its own breed of cat. Are we going to see a replication? And could it apply to other types of disaster recovery and response if you wanted to segregate? Potentially. I maybe lean into Randy if she's got some examples there that she wants to bring to the table. But I think, this was a unique case, and I think it was well thought out by this applicant and how they wanted to approach it to make that distinction. Again, FEMA wasn't willing to kind of acknowledge it on the front end, but going through the process, I think it could be applicable in the future for other events as well.
I really hope so. That the last point about social distancing is really interesting in the board's context, because the board has several times come close to the question of how direct disaster damage needs to be. There's a section of this presentation we won't get to. I urge people to look at the PowerPoint after the fact, but it goes through some of the cases where the board has come close to discussing where that line is. So in this case, originally, as the board describes it, the board rejected that it was a direct disaster emergency work because, after all, people had to violate a social distancing rule in order to be in danger. And therefore, is it directly tied to a pandemic? It's almost a philosophical question about, like, how does this particular disaster work, right? It only works if people are not social distancing. I find it fascinating. I realize we don't have time for this, but if you are in this circumstance, I really recommend you take a look at this case. And for lack of time, let's go to the next slide, if we can. And one more. Okay, so we wanted to, before we leave, talk about cases that have been denied. So several COVID cases, and the same arguments keep coming up again and again. Judge Somers, I'd like to ask, so two questions. One, we have a great question from Wendy that we want to get to before we wrap here. But also, in this case, where you have a lot of applicants who have a lot of costs and good faith, they're trying to recover these costs, but they're making arguments that have been denied many times. Like, how would you counsel? Do you try to repackage it, or do you do more damage to yourself trying to raise an argument that just doesn't have support?
Well, I mean, I don't know whether you do more damage to yourself in the sense of it's always worth trying to figure out what will be the persuading description for the panel. But that said, looking at these cases, for example, we're in an area that is just really difficult to make a ruling on. Hazard pay before and after, for example, frontline pay. I mean, that's not something that was really talked about in previous FEMA cases. So it's just a whole new topic area. And I think it just makes it difficult to anticipate how the panel is going to rule on any of those.
Understood. And there was in the chat, Judge, there's a question from Wendy. If you have a second, we'll go with the next couple slides and then circle back to you if that's something that you can answer. All right, so in this slide here about premium pay, this is something that the board has rejected a few times. As Judge Somers just said, very difficult circumstance and case to try to argue. Be aware, though, of these methods that have not worked, so that when you make an argument, you're not going down the same path. Next slide, please. The other argument that keeps getting rejected is the increased operating costs we talked a little bit about. There are ways to get around it. So this is the first case that we mentioned that does have some recovery. We talked about Fayetteville and Joint Essex, which also found a way to get some recovery. But if we're just arguing for work that you were doing before and you don't have a policy that's explicit, the board has been consistent in refusing to read policies broadly in finding the overtime to be eligible. So you're probably going to need something more than just a boilerplate policy. At the very least, look at these decisions on the screen if you're trying to make this kind of argument. And Baldwin City is particularly important. So if you're in the situation of trying to recover damages for a disaster, and it's not because of COVID, but it's a disaster that happened during COVID, take a look at Baldwin, because some costs were approved and some costs were denied. But it's a very unique circumstance that's worth your attention. And the final one here, it ties back to Randy and Jamelin's discussion about nonprofits and how they speak a different language. It's the utilization of COVID costs for quarantine costs for nonprofits. So far, it's been consistently denied in every board arbitration that's come up on, but for different reasons. If you're in the nonprofit space, make sure you take a look at these decisions. The issue often comes down to state delegation of authority. So in Southern California, it was a state that was trying to comply with county and state rules to disperse and to quarantine personnel in non-congregate housing. And the question was whether that responsibility to house students, in this case, in non-congregate housing, had actually been requested and that had been certified that responsibility was being transferred to that nonprofit. The court found that there had been a request, but that there had been no certification. So a high bar and a complicated bar. I want to circle back on COVID here before we leave this section, because I imagine it's going to dominate the next couple of years of arbitration. Randy, Jamelin, any thoughts? Will? Anything? Good. Okay, we covered a lot of the waterfront. We have about 10 more minutes, so we will start with direct costs. All right, next slide, please. All right, so direct damage and proving methods of direct damage. It's, like I said, it's been an issue that the board has come close to a few times, but never decided on directly. Next slide. In some of these cases. So if you're a small applicant and you're trying to prove road damage specifically, I recommend you look at the Monroe County engineer cases. There are a series of 5 arbitrations, all done within 1 year, where the board was trying to prove, despite the burden of evidence and issues of deferred maintenance. And Will Polk, we were talking earlier about the issues with deferred maintenance and small applicants. And I wondered if you'd talk a bit about that in this context, how you help small applicants try to meet the burden that the court and the board implements to make sure that applicants can prove that damage that's affecting is coming from a specific disaster.
Yes, we had a situation here in North Carolina where we had, after Hurricane Florence, an applicant we had successive storms. We had Matthew in 2016 and then Florence in 2018. And then basically the applicant was a Memorial Hospital, Scotland Memorial Hospital, where the pre-existing determination and deferred maintenance was really, FEMA argued that was really what caused the damages to the facility and not Hurricane Florence. And so again, documentation and other things did come into play with that particular arbitration. The hospital argued that the flashing that was on the facility was acceptable. They did provide some maintenance reports, to show that they did do some maintenance on there. But the panel sided with FEMA in the sense that they felt that the evidence that was presented showed that the deterioration happened, prior to the storm, and and the damage that was due to the deferred maintenance was not eligible for it. And so, again, they found that FEMA's engineering reports were more credible than the applicant. So again, it really, gets to something at the core of what we talked about here, which is documentation and contemporaneous documentation. It's very, very critical whenever you're making these arbitration or appeal submissions to FEMA.
And in the absence of that robust documentation, I wonder, best practices. If you move forward one slide real quick, Ashley. So in these quotes, and the reason I put it in the slide, you have the board recognizing sort of the heavy burden for small applicants, but also recognizing that the burden must apply in order for FEMA to maintain the system here and ensure that applicants are deserving of the eligibility that they're requesting. There is sometimes a shift in the burden, providing that the applicant can demonstrate that it's passed inspections in the past. So it's discussed in star text, Jackson. That's why that's there. But to Will's point, next slide, please. There is several cases where the board will directly review evidence where the evidence itself is not alone sufficient, or there are gaps in the evidence. And the board will review the evidence for itself to try to determine if the applicant has met the threshold to demonstrate that it was directly due to the disaster at issue. And it's always very difficult to generalize findings from this because every evidentiary instance is different. But you can find a few through lines in the board's arbitration precedent. So one is that this first point here, the board often looks to the thoroughness of an inspection rather than simply to when it occurred in time in deciding how much weight to give to it. Best example of this is the Apostolic Assembly Church decision, where the board looked at actually a series of inspections that occurred months after the fact and ultimately found that was more demonstrative of wind damage to a church than the initial inspection executed by FEMA initially after the hurricane. That was another case where the church itself hadn't kept good records of the pre and post disaster condition of the church. The second bullet is a good example of the second form of the board's examination of evidence, and that is of survey and survey data. So it was a circumstance where the city had done a survey immediately, actually, I think it was a year and a half or 2 years before the disaster event, had assigned a pavement index for the roads at issue, and then had done the exact same methodology after the disaster. And because the methodologies were the same, they were able to attribute the damage in between to the disaster at issue, even on roads that weren't in great condition. So it's a great example of how, if you do have data, the board will examine it and attribute eligibility even in circumstances where the road is not in great shape. So in other circumstances without that, you might not have been eligible at all. And then the final case is a good decision to look at if you're assessing the differences, how different judges look and give different weight to the different means of making up that absence of documentation. So it's a case where one judge was swayed by testimony and inspections, where the other judges was swayed by documentation and photographs. And that was the decisive issue for them. So again, a judge-specific thing. I wonder, Randy or Jamison, do you have, when you do have an applicant that doesn't have good records or inspections, like how do you help them to try to put the best foot forward as a general matter, in arbitrations or appeals? It's any general advice on that front?
I find typically documentation or data exists, Sam. It's just whether or not it's been brought to the party. And so really drilling down into capabilities, what they are tracking, what they are looking at on a regular basis, and using what exists in order to, borrowing Jamie's comment earlier, translate for our FEMA teams in how, this data informs these decisions or these examinations of the equipment or building or structure, right? So,
more about finding what exists than having to recreate.
Right. Well, your equipment best. You know it better than FEMA does, and really, it's getting to the heart of the matter. And sometimes it's things that they don't even think about. I'm thinking of COVID at the moment, but I know that we did Google reports on streets for after Katrina, and taking snapshots of what the streets look like. And at that point, we could do core sampling. I don't think they're doing core sampling anymore. But those engineering decisions and engineering recommendations and opinions of what existed before and what the effects of the storms were played a huge part in receiving that for the roadways and the utilities underneath it. So it's really diving to the heart of the matter of what you're working with, and working with those experts who know how to translate your data and your situation into a translatable solution in accordance with guidance and regulations. I think it's knowing what they're looking for and knowing what's driving the questions is super helpful.
Well, yeah. Anything to add, Jamila?
Yeah, I was going to concur and then recognize that we're coming up on time.
We are. So any last comments from anyone on the panel? Thank you so much for participating. I really appreciate it. I know our attendees really appreciate it.
I would just say, real again, just to reiterate the earlier point I saw in the chat as well. Just make sure for applicants you do engage with your state, even if it's just a simple letter of support from the recipient grantee. I think it's good to have that. Like I said, as a matter of practice, even if we may not. Our agency, even if it's this argument equity, that's jurisdiction should be able to, receive reimbursement for their expenses. We will put that at least in there. But again, thank you all for being here today and listening to our thoughts. And I really enjoyed being a part of this panel.
Same here. I really enjoyed it. I probably can answer Whitney's question in just one sentence. Think about the Supreme Court. Sometimes someone's assigned a case to write the decision on, then they have to get people to agree to it, and then maybe there's a dissent. And so then somebody else writes it, and then everybody decides, oh, I like that better. And so that might have happened in that case. I don't know, but it's kind of like that.
Oh, and thank you. And if you go one more slide up, actually, that's everyone's emails address. Thank you much. I think that's all we have. Thank you.
Thank you. Bye-bye.
Thank you so
Thank
much.
you so much, Sam, Judge Somers, Will, Jamelin, Randy, for sharing your expertise with us today. Thanks also to our great audience for participating, engaging, asking questions. It's a very complex topic, so I'm glad we had the opportunity to address it and bring everybody up to speed. You can find out more about the NEMA Empowerment e-learning series and how to sponsor one of your own on the NEMA website, www.nemaweb.org, in the resources section. Thank you again to everyone for participating. Take care, stay well, and have a productive rest of your day.